Meanwhile, the Supreme Court of Appeal in Bloemfontein has dismissed the application by telecoms giant Neotel, challenging the legal grounds which led to the collapse of the multi-million-rand deal with Vodacom.
Vodacom's acquisition of Neotel's assets came to a halt after competitors Telkom, MTN and Cell C successfully challenged the validity of the contract in the courts.
In May 2014, Vodacom launched a 7 billion rand bid to buy Neotel. Vodacom had planned to acquire Neotel's fixed-line business assets. The deal was approved by regulatory body ICASA in June 2015, but its competitors argued that the deal would irreparably harm competition in the mobile market. The High Court concurred and put the brakes on the deal.
Our problem is the very same order that the appellant faces here, that there isn't an appeal against the order. We can't get away from that. And that is why we submit that a decision shouldn't be taken in isolation on the intervention application.
Vodacom, with more than 30 million subscribers, and Neotel have already pulled out of the controversial agreement. But Neotel continued to question the fulfillment of a 30% BEE obligation set out by ICASA.
The effect of this judgment means that my client will never be able to transfer control to anybody else who doesn't have a 30% BEE stake.
A full bench of the SCA dismissed Neotel's contention, this despite Neotel's reservations.
So my client and the industry are effectively held at ransom by the mere coincidence that there was more than one ground of appeal raised and that more than one ground of appeal succeeded. That, with respect, it cannot be a proper basis for removing the matter from this court's jurisdiction.
It was not immediately clear whether this was the end of the matter. Teboho Letsaba, SABC News, Bloemfontein.